Hello, everyone, and welcome to Season 9, Episode 6 of Me-Arcone Queing podcast, powered by Institute for Alternative Dispute Resolution. I am your host, Rishabh Sharma, and I am delighted to have you, sir, with us for another insightful discussion on the evolving landscape of dispute resolution. Today's episode is titled Resonating Peace, Rebuilding Trust, Dialogue as the Path to Resolution, where we explore how strategic dispute resolution can create not only legal solutions but also lasting trust between parties. In a world where conflicts are inevitable, the way we approach their resolution can make all the difference, both in business and in life as well. Our guest today is someone whose work truly embodies this theme, Mr. Utsav Saurav Sir, advocate and international mediator with around 6 years of specialized practice in a cross-border dispute resolution and complex litigation. He currently leads strategic initiatives as country chairman of Med-ARB International's India chapter and has represented India on prestigious international platforms, including securing second place at International Mediation and Diplomacy Competition 2025 in Cyprus. His expertise spans debt recovery, white collar crime, regulatory compliance, cyber litigation, and high stake cross jurisdictional matters involving clients from across the continents, from Argentina to Ecuador. Beyond his practice, he is an educator and trainer conducting global workshops on mediation standards for legal professionals. His approach combines diplomacy, innovation, and a deep commitment to ethical advocacy. It's a privilege to have you with us today, sir. We welcome you to the podcast.
Thank you, Rishabh. Honor to be here.
Sir, before we dive into today's theme, could you please share a bit about your professional journey so far and what actually drew you to specialize in mediation and arbitration?
My professional journey in dispute resolution commenced during my integrated BB LLB program at Calcutta's University, where I graduated as a lawyer from the session 2014 to 2019, where the foundational exposure to alternative dispute resolution mechanisms coupled with practical internships at various chambers, like at my hometown Patna, then at Delhi and at Ranchi as well. So this has crystallized my conviction that traditional adversarial litigation often perpetuates animosity rather than fostering sustainable resolutions. So the pivotal moment occurred during my tenure as a secretary of the 34th All India Inter-University Moot Court Competition in 2017 at my university, where I witnessed firsthand how structured dialogue and principled negotiations could transform seemingly intractable disputes into collaborative problem-solving exercises. This was further reinforced when I represented Team India, which you just mentioned, and recent. If you see, there is some recent global researches that validates these perspectives. That if you take SEASON, that is to Singapore International Dispute Resolution Academy, it conducted a survey across 26 countries in six UN languages. It found that international commercial mediation users experienced the highest satisfaction levels. It was more than 70%. And the cost for it, like 80% or it's more. So the significantly outperforming international commercial arbitration with like around 30% of cost with 45% of speed. And I may not be correct with the exact figures, I'm just giving it for reference, and international commercial litigations. So my specialization has been methodologically cultivated through comprehensive international certifications, including my designation as a certified international mediator. And I have done several other courses as well on international mediation and on international law in action, etc. And mastering the craft of mediation, where I learned all kinds of techniques of mediation. I learned all kinds of techniques of a negotiation, that how you approach to the party, how you approach to your client, and how you approach to the system. So
Right,
what
sir.
fundamentally drew me into this field was the realization that Mediation and arbitration offer parties unprecedented opportunity to maintain agency over their disputes, while accessing expertise that transcends traditional judicial boundaries, enabling um, value-generating solutions that addresses the underlying interest rather than merely adjudicating the potential claims. So this
Right.
has been my journey since then.
Sir, I must say that's a fascinating journey, and it really shows that how intentional choices can shape an impactful career in specifically ADR. So, sir, based on our research, I can find that you have an extensive background in cross-border dispute resolution and complex litigation. So, what initially inspired you to focus so strongly on mediation and arbitration as the preferred path to the resolution?
Rishabh, my commitment to mediation and arbitration stems from both empirical observations and philosophical convictions developed throughout my practice experiences as a lawyer. During my tenure at a law firm, I have been representing some premier financial institutions, and where I witnessed the transformative impacts of implementing pre-litigation mediation and ADR mechanism that is in Section 89 of the Act. It has been really well. It turned out to be really good for the client and as well as for the lawyer itself. So the quantifiable benefits were remarkable. We consistently achieved expedited settlements while generating significant cost savings for the clients, and we often reducing the resolution timeframes from years to months, and legal expenses by a major margin. If you calculate it, it would be like more than 50%. In some
Right, sir.
cases, it would be around 70%. So more importantly, these processes preserve crucial business relationships, right? That would have been irreparable. It has been irreparably damaged through protracted adversarial proceedings. Just take it for an instance that how mediation of these things works. If there are two parties, they are in a business engagement and they go to a court, one party will be penalized.
Right, sir.
So mediation gives them the power to get it settled on your own. That's the purpose of that, to get it settled out of the court, right?
Very true.
So since you asked, I'll tell you my some experiences with this. That my cross-border experience, particularly when advising an Argentine national on a complex property dispute involving alleged unauthorized occupancy over the ancestral land. So this reinforced many such things. Like, you know, what is I have realized that traditional litigation would have required navigating multiple jurisdiction frameworks for potentially decades.
Yes,
So
sir.
through structured mediation process, we facilitated meaningful dialogue that addressed fundamental concerns while preserving the dignity and autonomy of each party. Also, if you see the Mediation Act, it also signifies a monumental shift in India's approach to dispute resolution, right? While providing it a very comprehensive amendments to the existing statutes, including Indian Contract Act, CPC,
Yes,
the
sir.
LSA, Legal Service Authorities Act, and also the Arbitration Act. It has been demonstrating a systematic integration of mediation into India's legal frame while maintaining a voluntary principles. So
Right, sir.
this has been the entire framework which has been working.
Sir, as you mentioned about the Mediation Act and also pre-litigation mediation, so I am having one question of my own. That, sir, pre-litigation mediation is not made mandatory in the Mediation Act. It is voluntary, basically. So, sir,
Mhm.
do we think that it will be able to achieve the purpose of mediation? Because had it been made voluntary, then parties would have resorted to pre-litigation mediation for sure. But just because mediation as a core principle has voluntariness in it, the pre-litigation mediation is made voluntary. So parties may avoid it and directly go to litigation
Yes,
only.
absolutely. See, parties may avoid it. The entire purpose of it to get it settled outside of the court, number one. Second, it will save you a lot of time. The judicial time will be saved. So there are many factors that is affecting to this approach, right?
Right, sir.
So just take it for an instance on a personal level. If you are into a dispute with somebody and you want to settle it, why you want to waste all those years in litigation?
Right,
Why don't
sir.
you get it just settled outside the court, right?
Yes, sir. Yes, sir.
So it depends on your approach, that what kind of approach you are making towards the problem.
Right, sir.
If you are rigid to it, then no, I want this party to be penalized. It has done several wrongs to me. I want this, I want that. The doors are open. The court
Right,
is
sir.
there for you. But if you want to get it settled, get it done outside. Also, the act has now provided that there are many institutes now
Yes, sir.
by designated by the Honorable High Court, right?
Right, sir.
So everything is being within the four pillars of law. So we need to understand this, the basic idea, the fundamental principles, and the factors affecting to a problem. Once that is sorted, the choice is very easy whether to approach to the mediation forum or to the court. Also, if you go into court, the court asks you to take this matter to the mediation.
Yeah, yes, sir.
इसको मीडिएशन में लेके जाओ, देखो वहां पर क्या होता है, मीडिएशन की रिपोर्ट आएगी। एनआई एक्ट के केसेस में बहुत ज्यादा ऐसे होते हैं, दोनों
Yes, sir.
पार्टीज अगर आ जाती हैं, द कोर्ट ऑफन रेफर्स टू द मीडिएशन, जाइए आप लोग आपस में अपना डिस्कस कर लीजिए, एंड लेट्स सी,
Yes, sir.
राइट।
Okay, sir.
तो
So,
इट्स अ गुड थिंग दैट कि चीजों को सॉर्ट आउट कर लेना वुड बी मच बेटर,
yes, sir.
राइट।
That is the whole purpose of mediation and arbitration to get things settled
एग्जैक्टली एग्जैक्टली
expeditiously.
एग्जैक्टली।
Yes, sir.
यस
Uh,
टोटली, एंड व्हेन यू गो इनटू द मीडिएशन यू डोंट talk about the law,
yes, sir.
you talk about each other's interests, right?
Right.
You don't say कि नहीं या ये कानून है वो कानून है, no, you don't do that.
Yes,
You
sir.
have a problem, you come up with a solution, you have a proposal, and then you argue over the proposal, which is when when mediation often gets successful when there's a win-win situation, when both parties say, okay, I'm also being benefited by this issue, you're also getting benefited by this proposal, it's fine, let's get it settled.
Yes, sir.
If not, if somebody is rigid, go back to court, fight your case on merit,
Yes, sir.
trust the honorable judicial system, right?
Oh, okay, sir. So moving on. So, sir, my next question is that when you hear the phrase resonating peace, rebuilding trust, then
Mhm.
what does it
Mhm.
mean to you in the context of dispute resolution?
Okay. Resonating peace and rebuilding trust.
Yes, sir.
You know, this phrase encapsulates the transformative essence of effective dispute resolution practice while representing both methodology and ultimate objective of sophisticated mediation and arbitration processes, operating on multiple interconnected dimensions supported by the contemporary research demonstrating collaborative approaches, superiority over adversarial litigation, which I just mentioned in my previous response to your question. Uh, resonating peace, it signifies creating a harmonious solution that reverberate beyond immediate parties,
Right, sir.
generating positive externalities that strengthen a broader commercial relationship, right? The community ties, the institutional confidence in alternative dispute resolution mechanisms. So this resonance effect is particularly evident in a cross-border commercial disputes, where successful mediation outcomes often establish a precedence and frameworks facilitating future international business collaborations, which I just explained it to your earlier query.
Yes, sir.
And what was the other one? Rebuilding trust.
Yes, sir.
Rebuilding trust, the term itself represents so many things. It represents the constructive dimension, acknowledging that conflict inevitably damage the relation foundation between the parties. But skilled mediation can actually strengthen these relationships,
Yes, sir.
right? Beyond their pre-dispute states. I have a great concern in this matter that when a party goes into mediation, I don't find there is a bigger role of a mediator, right? But the major role is of the negotiator. The
Yes, sir.
way you represent your client, being a negotiator in a certain matter, is a solution of most of the things. Like it's similar that something which is happening inside the courtroom, right? Where you are fighting your case and you're not getting it settled. So for settlement, you have a different institution, right? So in my practice experience, particularly when serving as a co-negotiator in a I was a co-negotiator in a matrimonial dispute involving parties residing in Ecuador. I witnessed how trust building often proves more valuable than specific settlement terms.
Right, sir.
When parties experience genuine acknowledgement of their perspectives, their validation of their concerns, and collaborative problem solving that honors their dignity, they often emerge with enhanced confidence in their ability to navigate the future challenges that may arise in a very cooperatively manner. So the integration of these concepts reflect my understanding that effective DR transcends mere settlements achievement to encompass restoration and enhancement of human relationships,
Right, sir.
strengthening of commercial partnerships, and also the advancement of civilized approaches to the conflict management.
Yes, sir. I like how you have connected the concept and not just to legal outcomes, but also to restoring relationships. So, sir, you have worked
Yeah.
to expand dispute resolution
So that
services
is the
in.
purpose of the mediation, right? That the relationship should not be damaged.
Yes, sir.
If you are able to restore it or you are preventing it from getting it damaged, the purpose of mediation is you're already halfway there,
Yes, sir.
right? क्योंकि मैटर्स आज हो रहे हैं, प्रॉब्लम आज अराइज हो रहा है, कल को तुमको उसके साथ दोबारा बिजनेस करना है, यू विल बी
Yes, sir.
engaged to that particular organization or to that particular party or person again.
Yes, sir. Okay, sir. Sir, you have worked to expand dispute resolution services in India while maintaining global standards. So, how do you strike a balance between adoption to legal realities and upholding the international best practices?
Okay. Um, this challenge represents one of the most intellectually demanding aspects of international dispute resolution practice. As my country chairman and also as my designations in several associations and my experience in my all these years of short span of experience, I have developed a sophisticated framework for achieving this balance that honors both universal principle of effective mediation
Right, sir.
and specific requirements of diverse legal and cultural contexts. So the foundational principles involves maintaining unwavering commitments to the core mediation ethics, the confidentiality, its neutrality, its voluntariness, and also partly self-determination, while adapting process designs, communication strategies, and many things. So the other thing which is unnecessary to state. The International Mediation Institute's mission to drive transparency and high contemporary standard worldwide provides a universal guidelines that must be thoughtfully adapted to the
Yes,
local context without compromising the fundamental integrity, right? Whereas the Indian mediation framework, uh, it illustrates this balance practically. The Mediation Act provides comprehensive amendments to the existing statutes while maintaining the mediation remains completely voluntary and optional, while demonstrating how international mediation principles can be systematically incorporated into domestic legal frameworks while representing the local legal traditions. Also, over the last decade, India has strengthened its arbitration law to establish itself as a global hub of international arbitration, right? With the proposed amendments aiming to streamline process, to reduce the court interventions, and also the major purpose to increase the efficiency. If a mediation gets failed, your institute is not sufficient enough. It lacks sufficiency,
yes,
right?
sir.
So this evolution requires constant calibration between international best practices and local legal traditions, and also some regulatory requirements. And the most important thing which I have observed and learned from my cross-border engagements is you have to be up to the cultural expectations as well.
Right, sir. That is very true.
Yeah.
And sir, it is interesting that how you frame it as a balance rather than a compromise, ensuring that local relevance is there without losing the global quality. So, sir, moving
Yes,
on,
absolutely.
in cases involving corporate fraud, regulatory compliance, or cyber disputes, how do you rebuild trust between the parties who are deeply entrenched into the conflict?
Well, it represents one of the most sophisticated challenges in contemporary dispute resolution practices. These cases typically involve substantial financial stakes,
Right,
with
sir.
lots of risk, fundamental breaches of fiduciary duties, the regulatory violations are there, and reputational damage that can permanently alter the business relationship and also the market standing, right? And my approach involves a multidimensional strategy addressing both substantive issues and underlying relational dynamics damaged by the conflict. So the foundation rests on creating safe space for authentic dialogue where parties can express genuine concerns and interests without any fear or legal prejudice or strategic disadvantages. In corporate fraud cases, trust building typically begin with establishing clear protocols
Right, sir.
for information sharing that enables parties to demonstrate good faith while protecting legitimate interests. So this often involves structured disclosure procedures, allowing the incremental revelation of relevant informations, enabling parties to build confidence in each other's commitments before requiring the complete transparency. The regulatory compliance dispute require particular sensitivity to professional reputation and institutional integrity issues. And in cyber disputes, presents the unique challenges because they often involve the technical complexities that parties may not be fully understand. They may not be very well conversant with it. It creates an additional mistrust layers based on uncertainty
Yes, sir.
about the actual problem and scope of the nature. So trust building often requires engaging technical experts who can provide a neutral assessment, enabling parties to move beyond speculations towards evidence-based problem solving. And the practical implementation, the practical implementation involves a careful sequencing of mediation activities, beginning with separate party sessions for confidential exploration of underlying the interests before moving to the joint session focused on collaborative problem solving. And I will end my response to this with that one particularly effective technique involves developing contingent agreement structures
Right, sir.
that enables parties to test renew trust through limited collaborative arrangements before committing to the comprehensive settlements or any kind of settlements, often including which is often including performance monitoring mechanism and graduated escalation procedures as well.
Right, sir. Sir, moving on further, could you please share an example where the application of pre-litigation mediation that we were talking about recently, those particular strategies have resulted in a resolution that litigation might not have achieved?
Oh, there are many. There are many, but I'll tell you one. One of the most illustrative examples involved a complex multi-party commercial dispute between three different corporations, the two Indian firms and one the multinational corporations. So the dispute arose when the multinational partner accused the Indian firm for of incorporating proprietary algorithm into the independent products, while the Indian companies claimed the multinational had violated the exclusive agreements by simultaneously developing the competing products with the other partners. I was not directly involved into the case, but I found it very interesting. I was assisting somebody into the case. The complexity was compounded by technical nature of the intellectual property got involved, which I was not very well versed with that area of law. Then the international dimensions of business relationships, which I learned, and regulatory implications under both the Indian and international technology transfer regulations. So litigation would have required extensive expert testimony. There are a lot of factors that gets involved into this, into such
Yes, sir.
disputes or crisis. So the litigation would have required extensive expert testimonies, there an involvement of many experts and complex discovery procedures across the multiple jurisdictions, because once you go cross border, the complexity in itself rises to a height, right? That it achieves optimum level because you have to comply with your law of the land, their land, the international norms, and there are so many things. So the experts are very, very much needed. Through pre-litigation mediation, we created structured dialogue processes addressing both immediate contractual disputes and underlying business interests, originally motivated the joint venture. Right? So the breakthrough occurred when we shifted focus from the past alleged breaches of to further collaborative opportunities. Because once you go into mediation, Rishabh, ये नहीं सोचना होता कि yes, this is what you have done and you would do this again. You have to be in a very positive approach there, right? So most significantly, the mediation process, I won't be able to share more details of the matter with you for the purpose of confidentiality we had. But most significantly, the mediation process enabled the development of standardized intellectual property sharing protocols and dispute resolution mechanism that have since been adapted by other technology partnerships, and that has been creating a positive externalities extending for the beyond the original parties, you know.
Yes, sir. Sir, that's a really matlab, perfect illustration of how mediation can achieve outcomes that code simply cannot replicate, I believe.
No, no. Moreover, it will demand a lot of cost, lot of time, right? पता चला तब तक तुम्हारा मैटर नहीं बाहर सॉर्ट आउट हो गया, मैटर कोर्ट में अटका हुआ.
Yes, sir. That might also be
there,
the
there,
case.
there are so many factors that varies, and that is also one of the factors that mediation got into the picture, because
Yes,
there are
sir.
so many cases pending there कि भाई इसको बाहर ले जाओ, get it settled outside out.
Yes, sir. Now, sir,
If
Supreme
there
Court
is
judges
if there is a
also.
scope of settlement, only then.
Yes, sir. And so now Supreme Court judges also emphasize on the same that pre-litigation mediation is very important thing. It must be followed.
Yes, you cannot file a commercial suit before the honorable court if you don't have that
Yes,
non-starting report. कि
yes,
आपने
sir.
pre-litigation mediation किया, you get a non-starter report कि it will commence. Only then you can file a commercial suit, right?
Yes, sir. Okay, sir. So moving on, you have conducted specialized workshops worldwide on mediation standards. What key skills do you believe are missing in the next generation of dispute resolution professionals?
Uh, Key skills. See, the art of negotiation. The art of negotiation, it lacks a lot. I have been with many such associates, and I cannot explain this answer much, but this is one of the things that the art of negotiation, which if not trained correctly, it will damage you. It's like art of cross examination. If you're not correctly um, trained into that, it will damage you. So one has to learn that. One has to learn the techniques, go out, read some books over the techniques, get yourself trained. There are many institutions that do the training you through uh, ways of certifications and lectures and everything. And also patience. You have to practice, you have to taste failure. Only then you would be able to achieve that parameter of success, or else you won't be. But these are many things that I find difficult in this generation. So they are being very impatient. They find it the field of mediation too easy,
Yes, sir.
because I can tell you with my personal experience, because this is also which I didn't mention in my earlier response. This was also one of the reasons I got into it.
Yes,
I
sir.
thought यार ये बहुत ही डिफरेंट फील्ड है, ये लॉ है, ये है वो है. सो एक काम करते, बात ही तो करनी है,
Right.
इसमें तो हम एक्सपर्ट हैं भाई, है तो लेट्स डू
Right, sir.
दैट. विच टर्न्ड आउट इवन मोर डिफिकल्ट, कि बात ही तो करनी है, पर क्या बात करनी है और क्या नहीं करनी है, ये बहुत ज्यादा इंपॉर्टेंट
Yes, sir. And
है
here,
ना.
sir, I
तो
would also like to share
ये
one of my. Okay, sir, you please go.
No, no, please, please, go ahead, we are having conversation, it's good.
Yes, sir. So, sir, actually, I was a part of a mediation competition, and for the very first time, I
Hmm.
was acting as a negotiating party. So, I was basically the
Hmm.
counsel who was representing the client, and I thought it would be very simple for me to do that. But, sir, when I was sitting there and having a conversation with the other person, it was very difficult for me to come onto a negotiation settlement. At the same time, I have to
Hmm.
ensure that both the parties' interest is taken into consideration because I was completely focused that my client's interest should be saved. I was not thinking about the other person. So we were finding
Hmm.
it very
Hmm.
difficult to reach out on one settlement. So mediation did not
Yes, it
happen.
happens. It
We
happens.
lost the competition, and more than the competition, we lost the key skill that is required in order to become a good negotiator or basically a mediation advocate.
Yeah, it happens. It happens. Mostly in every competition, it happens.
Yes,
When
sir.
I was representing Team India, it happens. And when the coordinator, they announced that you have 15 minutes left, सारे के सारे सिम्टम पे आ गए क्योंकि भाई सेटल करो इसको,
Yes, sir.
है ना? तो ये चीजें होती हैं. And see, there, if you ask for me for advice for the young lawyers and mediators which are aspiring to create a meaningful impact to the dispute resolution, um, if you allow me, can I give you step-by-step advices? Um, I would advise the first develop a uncompromising commitment to continuous learning, right?
Right,
Which is extending far beyond traditional legal education to encompass psychology, business administration, because if you're dealing in mediation, if you're dealing with the finances, you have to be well versed with that. You have to be well versed with the concepts of business administration.
right, sir.
Then the cultural anthropology comes into picture, international relations. If you are dealing with the cross-border disputes, you should know the geopolitics as well. And you should know it pretty well. नहीं होता है, यूपीएससी का प्रिपरेशन कर लो, सीख जाओगे. और watch some videos. So just like tutorials, YouTube, पे there are many. You can just go and so the most effective, the most effective practitioners, they understand human behavior.
Right,
They understand the commercial dynamics, the cultural nuances. The Latin American family and the Indian family, they're basically the same. When I was dealing with that in the case, तो हमने ये फोकस किया कि उसकी फैमिली क्या सोचती है. When they are making the statements, we thought ये तो मेरी फैमिली है.
right,
They
sir.
talk like this, right? And you should seek every possible opportunity for hands-on experience, beginning with the internships, providing exposure to the actual dispute resolution proceedings. ये एक myth है तुम्हारे दिमाग में जो मैं लोगों के मन में होता है, खास के जो नए नए फील्ड को ज्वाइन करते हैं कि मुझे तो प्रोसीजर सारा जानना ही जानना है. It will take you hardly 30 days to uh, remember all those things, to learn that. उससे ज़्यादा नहीं लगता. क्या करना होता है? केस फाइल करनी है, आप फाइल प्रिपेयर करोगे. नहीं, हमने तो भाई फाइल प्रिपेयर करना सिखा दिया.
Right.
The best teacher in a law office is a office boy, that
Yes.
clerk,
Very true, sir.
right? उसको अपना गुरु बना के रखो, वही तुम्हारे काम आता है.
Yes, sir.
And you should also develop a specialized expertise in emerging the areas rather than attempting to become a generalist. But in initial layer, I would advise don't do that. People often say इस चीज में तुम्हारा एक्सपर्टीज है, इसको ही फॉलो करो. ये तब होता है जब तुम एक लेवल अटेन कर लेते हो. शुरू में तुम्हारे पास, तुम सिर्फ क्रिमिनल केस कर रहे हो, तुम्हारे पास एक मोटा सिविल का मैटर आएगा, आप मना कर दोगे.
Right.
वैसे लॉफुली तो वैसे भी नहीं कर सकते. यू कैनॉट से नो टू अ मैटर,
Yes, sir.
राइट? बट स्टिल आप उसको मना नहीं कर सकते. तो डोंट जनरलाइज इट. उसको और उसको स्पेशलाइज भी मत रखो. जस्ट मेक अ ब्यूटीफुल फ्यूजन आउट ऑफ इट. ये भी करेंगे, ये भी करेंगे, पर इंटरनली मेरा फोकस इसमें ज्यादा है.
Right.
Right. So you should also, for this, you should invest substantial effort in developing emotional intelligence.
Very true, sir.
And emotional intelligence is very much rare. You will not find it मतलब किसी किताब में कि क्या है. Because when you are dealing with the client, when you're dealing with the opposite party, you have to get into his minds. You cannot सीधा सीधा as a negotiator आप उसको, you have been into those competition, you should know, आप सीधा उसको जा करके ideas बोल नहीं सकते. You have to use several techniques to drop ideas into his mind कि तुम बोलो,
Yes, sir.
right? So these are the parts of the negotiation. So I think um, training is very much required, and nobody will train you. Training is required, but nobody will train you because nobody knows how to train somebody. दे विल कम विद अ बुक, दे विल कम विद अ पैम्पलेट पीडीएफ फाइल कि ये कॉन्सेप्ट होते हैं, ये बाटा टेक्निक होता है, ये टेक्निक होता है, वो टेक्निक होता है, इसको रट्टा मार लो. लेकिन कॉन्वर्सेशन में कैन यूज इट? नो. So emotional intelligence is that factor. Your empathy is like a brahmastra to any negotiation. Let me tell you.
Yes, sir.
If you're being empathetic to the opposite party, कि नहीं नहीं मैं सब ठीक कर दूंगा ये वो. Basically, what you are doing, you are gaining their trust. आप उनका भरोसा जीत रहे हो, right?
Right, sir.
This is how everything works on. So training is training, patience, knowledge, and yeah, knowledge. Keep learning, keep that hunger,
Yes, sir.
and lots of failures, lots of failures. I'm still a failure. I still fail. I still get up. I again fall down. So these things happens. It's a part of profession.
Yes, sir.
Can't deal with that. Yeah.
And sir, with that, you have also answered the final question, which I was about to ask, which was this only, that what advice would you give to young lawyers and young law students? This you have already answered. So, sir, I'll say that it's a valuable
Yeah.
advice that you have given, and I really think it resonates with anyone trying to build a career that is both impactful and principled. And
Yes.
sir, moving on, as we have to wrap up within the time, so I would like to conclude the session. So, Utsav sir,
Yeah.
thank
Please,
you
please.
so much for sharing your insights and experiences today. Your journey is a reminder that dispute resolution is not just about resolving a legal problem. Rather, it is more about rebuilding trust, understanding cultural context, as you mentioned, and creating sustainable solutions. To our listeners, if you
Yes.
found
Yes.
value in today's discussion, be sure to share this episode with your colleagues and friends and continue the conversation about how dialogue can be the most powerful path to resolution. I am Rishabh Sharma signing off from the Me-Arcone Queen podcast. Until next time, keep resonating peace and rebuilding trust. Uh, sir,
Thank you. Thank you, Rishabh.